at Pacific Cascade Legal. I'm here with our founding attorney, Louis Landerholm, to talk about what goes on in an initial consultation. So, Louis, how are you doing today?
Yeah, I'm doing great, Steve. How are you doing?
I'm doing well. I imagine, a lot of folks who call in, and they call in every day to set up an initial consultation. And they probably not only have questions about their case, but about what happens during the initial consultation. So let's talk about that. What happens in a typical initial consultation, if there is even such a thing? And for instance, how does it start?
Yeah, I mean, there's normally a consultation is similar to, from each one. Normally what I'll do is ask for underlying facts about kind of the situation, you know, what everybody is going through as far as what are the issues like from a, asset standpoint, from a, there's kids kind of a kid standpoint. One of the big things that I ask is if wife or partner or husband, the other side, if there's been conversations about that this is going to happen, because that helps in the consultation to understand kind of where in the decision making process, where are the discussions. So any previous discussions about any sort of agreements or kind of ideas just helps to guide the consultation. So those are the main things that I do at the beginning is kind of, and then if there's been, a case filed, then we can talk specifically about process and that sort of thing.
So do you get into discussing legal issues, either just in a general format or as part of their case?
For the most part, because we're not hired as their attorney yet, for the most part, we're not giving specific legal advice because in a 30-minute consultation, 20-minute phone call, whatever it is, you can't really diagnose everything. I mean, there's too many nuances that could happen and could come up to go through all of the if then options. And so generally I'm providing kind of an overview and a high level view of how the law deals with the issues so that people have an idea of kind of what can happen, what does happen, what's possible, all of those things, so that it can be applied to their individual facts. But I mean, everybody's situation is complicated and different, and so it takes more time to really dig into the underlying situation to provide specific legal advice to for their case.
Is this open to a sort of a question and answer period? I mean, do you get many questions during the consultation?
Yeah, for the most part, we get a lot of questions. Some specific questions, some more general questions. And again, I remind people like I can't tell somebody what to do or not to do because I mean that's just not good, not good lawyering if I'm
Right.
talking to somebody for 10 minutes and then tell them what to do. There's too many things that could impact that decision. And so, we have to punt that to once somebody's a client and we can actually have a strategy session and dig into the facts a little bit more. But for the most part, I can answer questions, in a general but specific way of how it would apply to their situation, just not directing them, yeah, do this or that. And so, it's kind of all over the board. But there's definitely for a lot of people I always start with like, what's the area that you are worried about the most? What are you trying to figure out the most so that it kind of helps to give them a little bit of peace of mind and direction on how the law works there.
I imagine you get asked a lot, will I get this? Can I win? Those kinds of questions. And that got to be, like you said, hard try to answer those in 30 minutes.
Yeah, and I mean, in family law specifically, and this is what I tell people all the time, win is very subjective. You know, for one case, a win might be getting any amount of spousal support. In another case, getting to have overnights with your kids could be a win. Another win, full custody, or another case, a win is full custody. So the win is runs the gamut, you know, um, for each individual client. And so, you know, it's impossible to, you know, define what a win actually is until we get into a case. And really the biggest thing in a consultation for us is, you know, we want our potential clients to feel like working with us is a good fit, just as much as we want to determine if working with the potential client is a good fit. And a lot of that is, can, you know, during that consultation, does the person who I'm having a consultation with, are they reasonable? You know, I'm going to give some answers that aren't the answers that people want for the most part, right? I mean, the law doesn't just say you want it, so therefore you get it. You know, the law says this is the law and how it applies to your specific set of circumstances. So some of those conversations are difficult conversations, and that we want to understand if our expectations can, you know, line up as much as possible, so that, you know, because our style is not a style of we're just going to go and say we're going to do whatever you want. You know, we'll advocate for all of our clients to, you know, and do that with, you know, great skill. And but we also want to work with people who want the advice, who understand that we do know what we're doing, and that there's a give and take there, and the conversation is, you know, is a reasonable one, and everybody, you know, understands how things are going to work as we move forward.
It would seem that for anyone watching that's going to go into one, the need for that person to be really open and honest and willing to share the good and the bad right at the beginning would be pretty important to help that sort of assessment and bonding.
Yeah, I mean, having done this type of work for so long, I mean, you know, there's a number of us who've done it well over, you know, 10, 15, 20, 30 years. You know, it's a no judgment zone. We've seen everything, right? Like, we don't care what the answer is. We just need to know what the actual answer is, because we can deal with the facts. It and that helps to, you know, just set some, you know, the groundwork and the expectation about what can actually be done in a case. Because if we're missing facts, that could, you know, have a huge detrimental effect on how the law would apply to it.
Yep. And that leads to the question, because I know you have this discussion, and it's, you know, fees and costs. And it seems like if you know everything, or know as much as you can give a much, you know, better sort of estimate of what's going on. But I imagine that's not necessarily an easy discussion to have.
Yeah, I mean, I think you know, when I'm talking to people, there's the retainer conversation, and, you know, the retainer is the initial deposit to get the ball started and to get the case filed and get it moving. Then I try to have the give, you know, I tell people all the time when people ask, like, how much is this going to cost? I try to give goalposts, right? And say, you know, there could be wide ranges. Best case scenario, you know, it's X numbered based off of the facts. You know, people who are talking together and who have started the conversation and it seems like everything's going to be amicable, they're going to save a lot of money. People who we know that the other side is going to, you know, fight for everything and scorch the earth. You know, I mean, you could have a delta for the amount of money, you know, be 5,000 to 50,000, you know, based off of how contentious it's going to be, based off of who's playing games with assets, or who's doing this with, you know, with the kids, or keeping the kids away from somebody else. I mean, there's just signals at the beginning of cases, kind of how a case is going to go. And, we want to try to get in and control some of that so that we can bring it back to a more reasonable place. But sometimes it's not possible. Like the other side is just, they're out to make it as difficult as possible. Yeah. And unfortunately, that means it's going to be more expensive to get to the finish line.
Yeah. And do the potential clients respond? How do they respond? I guess I'm asking is, this is the time for them, I would imagine, if they've got, concerns about the finances, to bring it up now.
Yeah, I mean, we talk about it that, not only do we have to solve the legal problem, but we also have to solve the financial problem of the case itself, because, it's not cheap. And you've got, if you've got an attorney, and then your soon to be ex is going to have an attorney, and then you've got the court, 3 out of those 5 people we can't control. And so there's a lot of moving parts that, that we can't necessarily foresee. So we want to make sure that, we can't rely on best case scenario, because, it doesn't typically go best case scenario. So then it's talking about, how do we minimize, using mediation, using judicial settlement conferences, using other mechanisms, negotiation. What does our client care about more than other things? What can we give up to negotiate something that you want to get? So it's trying to just set the tone and all of that. And, and one of the things that we help with is we do have a third party, financing company who works with us for especially the initial retainer to get a small personal loan to be able to, at least get the case started. Because the other part is that, the case typically is going to take a year. So, give or take, I just tell everybody, just count on a year. So that total amount is going to be, spread over that year process. And there's ways to go get support turned on. There's ways to go get pre-distributions of assets. There's ways to do all of these things. But we just have to make sure that we're all on the same page, and make sure that, that somebody can, finance the case all the way through, just as much as, being able to work the case.
I get a question sometimes, or you hear about people wondering, I went to see this attorney and talked to them, and they must have said something because yada yada. But confidentiality is a huge thing, and I think people really need to know, your need to be confidential, and your requirement to be confidential.
Yeah, I mean, everything that we say, has confidentiality. Some of the things that destroy confidentiality are if a third party is, on the phone call or listening to the phone call, they could be made to testify as to what was being said, in a consultation. So, some of those things are important to talk about, especially if we're dealing with, issues that are very sensitive, like if there's, DHS allegations or whatever, criminal allegations or whatever it is, we want to be really careful about opening up certain things. And so, everything is confidential for us. We just want to make sure also that it's confidential going the other way, and that everything that the attorney says to the potential client is also covered by, that confidentiality. And so, it's a balance with all of that, because people have their support system and they want to use their support system, but, we don't want it to, backfire and cause a problem in the case as well.
Oh, good idea. You had talked about assessing whether you're a good fit, and the consultation, I imagine, is, do I have to hire you? When am I required to hire you? That kind of stuff. And maybe if I do hire you, what next?
Yeah. Yeah, so I mean the do I have to hire you when all of that? Normally that comes into play when there's already a hearing or a trial that's been set. Depending on and not and this is the hard part for potential clients because they don't do this every day. Not
Right.
every hearing is the same hearing, right? I mean, sometimes we're talking about a trial, a 2 day trial. That's a different situation than a status check. That's a different situation than a temporary hearing. That's a different situation than a restraining order hearing. Like they all have their own demands and their own requirements and evidentiary rules. And I mean, the rules are the same, but the demands of evidence, depending on the facts. And so there isn't a blanket rule of like how soon before a hearing, do they need to necessarily hire? But sometimes that does come into play. Sometimes we just don't, we don't have the ability to jump into a 2 day trial a month in advance. There's just not enough time to get up to speed because the judge doesn't care when we jumped in. The judge expects it to be prepped the right way. And so, and there's some nuances, there's some ways to go have the potential client go get file a motion for a reset. And then if it could get reset, then we can hire. So it's always worth asking the question. It just doesn't necessarily mean that that we'd be able to take a case on like for in the county specific in Clackamas County, we know that it's going to be harder to get resets to push the timeline out, where other counties it's easier to get resets. So all of those things impact the whether we can take a case on or not.
Assuming that then the potential client says, yeah, I want to hire you. I like it. I like you. I understand the cost. I understand, what you've told me. I want to go. What are the next steps?
So it depends on the case. Most cases, somebody hires, then they get assigned to attorney and paralegal team who's going to be working on their case. That's dependent on issues, dependent on geography. Since we have locations from Eugene to Tacoma, we have people in the local area for a reason so that, they know the judges they're, closer to dealing with the case in those local areas. Um, so all of that, and then from there, I'll provide the notes from the initial consultation that I've done, and then the legal team will have a much more thorough like strategy session to really lay out the entire plan of what needs to happen when and what they need from the client and what's gonna timelines on our end. So from there, it just sort of builds the entire case plan at that point.
The the person who then decides to go forward, um, you said you match them with a set of attorneys, and how long about normally do you talk about this, that they'll be someone will get in contact with them to set up another hearing to go into a lot more detail?
Yeah, that would be paralegals reach out either same day or next day to to schedule that. And then obviously it's based on the reason we do it this way is that then we're not relying on our attorneys' court schedules that get in the way. And so, but then at that initial strategy meeting, sometimes they are prepping or in court. And so that can take, a couple days or whatever that looks like. Because the court has their own their own demands, and if you have to be there, you have to be there. So but that's why we do consultation this way so that people don't have to wait for an attorney who's working around a court schedule.
Yep. And we didn't talk about this, but quickly, I just want to hit it. You don't charge for these, do you?
Right. Yeah. So our initial consultation are free of charge. So they're complimentary. We generally do them 15, 30 minutes. It's a way to, just introduce the firm to them and diagnose the initial issues that are coming up. But yeah, we don't charge for them.
So it's about time to go. But if you had one thing you could say to someone who's thinking about whether or not it's worth it, or they're scared, they're confused, what could you reassure them about an initial consultation, and how much that actually can help them make a decision?
Yeah, I mean, it's huge because again, we handle hundreds of cases, so we see all of the facts and how the law applies to it, as opposed to trying to go to the internet or go to friends who have seen one instance here or there and applying it. Like, it's just impossible to do that. And we have the knowledge base to be able to apply the facts to the law and explain how it really works. And so a 15-minute conversation can save hours and hours of time trying to figure it out on your own. So it's always worth having the consultation, especially since we don't charge for them. And then you just know what to do from that point forward.
And I imagine that once it's done, and even if they don't hire us, that doesn't mean that there's some sort of a foreclosure there, that they can't come back. Because a lot of
Correct.
times people may not hire or may try something else, but they're always welcome back.
Of course, yeah.
So it just seems like a really win-win thing for everybody. Hey, Lois, thank you for sitting down to talk with us about this. What goes on in an initial consultation? Because it is one of those little things that people are unsure about, because some people call an initial consultation something that's different, and yours actually is. So thank you. Everyone else, thank you for joining us today. If anyone has any further questions, please feel free to contact our firm. We can get you connected with an attorney who can help. Stay